We have talked a lot about privacy impact assessments. Let's sum it up by talking about the context in which the regulators are talking about privacy impact assessments. Welcome to my YouTube channel where you daily see new content on data privacy. And as I said, let's talk about the context of the regulators in which they talk about privacy impact assessment. What is privacy impact assessment? A special kind of assessment which you do on each and every data processing project. And if I refer back to the Indian DPIA Act, if you collect, use, share with third parties, delete or store personal data of any citizen of India, then you should be compliant with the Act, then you should take care of all the data privacy norms, right? And the privacy impact assessment says that the moment you start doing any of these 5 activities, you should reassess all your processes to see whether they are compliant with the regulations and norms of the data privacy, right? And if you feel that they are not, if you feel that there is a possibility of breach, then you should create mitigation steps to minimize the risk of the breach, avoid the breach, and the impact of breach, if at all it happens. This also helps you measure your own compliance with the laws and the regulations within India and even outside India in the global context as well, and we are going to discuss them in this video. It also helps you adopt international standards and improvise your own internal policies and procedures. So that's about the basics of privacy impact assessment. That also gives you the benefits of identification of risk when you are trying to process your information, mitigation of risk when you are handling or finding out what kind of risk is there in your processes. Of course, that would build the trust of internal stakeholders, but that would also build the trust of your external stakeholders, which is your customers. Your employees also become stakeholders because their personal data is also with there. And by doing privacy impact assessment, you spread in your organization that you are talking about privacy. So the privacy awareness increases within the organization and helps you take a better or more improved decision. The regulators now, the GDPR, the General Data Protection Regulation. Interestingly, Article 35 does mandate conducting a DPIA, which is data protection impact assessments, the one that you do on highly sensitive data or high volumes of data. They don't specifically talk about privacy impact assessment, but then Article 24 does focus on steps to ensure the compliance. What does that talk about? They don't use the word PIA, but they say that you should use a tool through which you can demonstrate your own accountability. And PIA is an act in a tool which can help you do that. PIA is a broader view beyond DPIA, right? DPIA is only for highly sensitive or high volumes of data. PIA is far beyond that. So PIA can always act as a complementary thing to DPIA. The information which may not be sensitive or which may not be high volume is also important, right? So you need to be very careful about that. The PIA also gives you a broader level of risk with your data privacy. Then you talk of the Indian DPIA Act. Again, the Indian DPIA Act does not specifically talk about doing a privacy impact assessment as such. They also talk about DPIA for their significant data fiduciaries, but they also want their fiduciaries to be accountable for the data processing processes, right? And they also want that their fiduciaries should publish their compliance from time to time, and you can publish that only if you are measuring them. And PIA is a very good tool that helps you measure the compliance, the risk management that is there in your organization, and demonstrate how compliant or how accountable your organization is towards data privacy matters. Then comes other smaller regulations, not so small but smaller in context of PIA. None of them is talking directly of PIA, whether you talk of CCPA or CPRA. Again, they are also talking only about handling critical sensitive data or high risk activities data. The APEC talks about risk management as a part of cross-border data transfers, right? So they are also more focused on transfer impact assessments. And the LGPD of Brazil, which is made on templates of GDPR, they talk of assessment again also of sensitive data processing only, and not about the normal data processing or not so large volume of data processing, right? So in the nutshell, you would see that none of the regulators are particularly asking you to do a privacy impact assessment, right? They are not using the language PIA or privacy impact assessment, but they expect you to perform your risk assessment, and that's what you do using a PIA. They expect you to have your mitigation plan. If something would go wrong, how would you resolve it? And if you can sense something can go wrong, how do you resolve it right now. You may not implement the complete mitigation thing, but at least there should be some plan of what you are doing. You should measure your compliance, and you should be accountable for processing practices that you have in your organization. And since the regulators expect you to do all this, it automatically means that your regulators expect you to do an assessment, which the world of data privacy calls it privacy impact assessments. So that's about the regulatory context of privacy impact assessment. We're going to get more detail into the Indian context in the coming videos, so stay tuned, subscribe to my channel. If you like my video, please press the bell and the like icon and share your feedback in the comment section. Thank you.